warahmatullahi wabarakatuh. My name is Nur Hazwa. So here I want to present the introductions. Women employees are protected at work, as stated in Part V11 Employment of Women in the Employment Act 1955. This act is meant to make sure the rights of the female employees are being protected. Not only by that, as this act is made especially for the female employees, these acts are made special for the protections of the female employees at workplace. The act does not require equal pay for equal work, nor does it allow the discrimination faced by the female employees. The provisions stated in the act are relating to women mostly concerns working hours and maternity benefits. In 2012, the report of the Organization for Economic Cooperation and Development has stated that in its members countries' employment rates are 30% lower for women than for men. Occupations available to women are impacted by their race, class backgrounds, immigrant status, and marital status. It can be seen that there are still prejudices in terms of the employment for women, and although there have been some significant change, there are still a lot of changes that have to be made to ensure the right for the women in the work sectors. Therefore, in this assignment, we will be discussing on the provisions in the Part V11 Employment of Women Act 1955 on how its effect in the workforce of the female employees. That's all from me. I'll pass to the next presenter.
Assalamualaikum, my name is Asman Ifambe Ismail. Today I would like to present about two provisions on female employees in Malaysia as stipulated in the Employment Act 1955. The first provision is Section 34, Prohibition of Night Work. Regardless matter the condition, women are not allowed to work night shift because Section 34 of the Employment Act safeguards working women's right in Malaysia from working at night. Its employer has no jurisdiction to force its female employee to work longer hours during night shift. Employers also are not allowed to make female workers work between 10 p.m. to 5 a.m. A business cannot also require its female workers to begin work without getting 11 hours of rest. However, this provision only applies to industrial and agricultural fields. As a result, women in commerce, hospitality, public health, and entertainment may work late. If the employers persist in doing so, they may need to apply to the Director General of Labour to waive the restriction, which the Director General may approve if certain conditions are met. There are various reasons why women are not permitted to work night shift. One of it is to ensure their safety at work. We are all aware the numbers of criminal cases filed in our nation is growing every day, with most of them affecting women's rights. Women employees are more vulnerable during night shift because of the dismal mood at work, which will instill anxiety in any woman in that circumstances. That is why, among other things, Section 34 of the Employment Act prohibits women from working at night. Every employer should take this topic very seriously for the company image and raises concerns among employees about their safety at work. The second provision on female employees in Malaysia as stipulated in the Employment Act 1955 is Section 35, Prohibition of Underground Work. According to Section 35 of Part 7 of the Employment of Women, it shall engage no female employees in any underground working. Underground works, in this sense, refer to all construction activities that take place beneath the earth's natural surface and within a contained environment. Even though this rule is intended to safeguard female employees, it has the unintended consequences of restricting women's work opportunities. Underground employment is dangerous and has a lot of adverse effects for women employees. As can be shown in several aspects, however, it can be argued that the underground work economic growth is steadily expanding and benefiting the country economy. Subterranean resources extraction is extremely rare in Malaysia's present economic context. Therefore, this might be viewed as an opportunity that female employees should seize. Not to be forgotten, most of the law and facts in Malaysia Employment Act are based on the British economic background because these provisions were enacted decades ago. The Act relevance does not match our nation's present state of growth. Women have come a long way and are now on par with males in many areas including education, skill and status. It has nothing to do with the evolution of employment in the past when women were traditionally viewed as housewives. This is where we can see the real thing, where women can compete with males in the workplace. As a result, it is reasonable to conclude that Section 35 restriction of subterranean labor is only a written statute that cannot be entirely relied upon unless there are exigent circumstances. That's all from me. Thank you.
Assalamualaikum, my name is Muhammad Amir Azmi bin Abdul Khalid, and today I'm going to present the third and fourth provision for women employees in the Employment Act 1955. The third provision is in the Section 36, which is prohibition of employment by the minister. According to Section 36 of Employment Act, prohibition of employment by minister is about the prohibit order of female employees under the certain condition by the minister. This section is the continuation from the Section 34 and Section 35, which are prohibition of night work and prohibition of the underground work. Based on those sections, the government have a right to do a prohibition toward women employees in order to protect them and to avoid discrimination in the workplace. For example, in the Section 34, the government implement that women employee is not permitted to work after 10 p.m. to protect them from sexual harassment and rape. Since it has been implemented by the government, the rape cases in the workplace has decreased in numbers in 2020. For the last provision is maternity protection. In the Section 37 of Employment Act, female employees are entitled to maternity leave for a period of not less than 60 consecutive days in respect of each confinement and shall be entitled to receive maternity allowance during their eligible leave period. In Malaysia, women who work in the public sector entitled to 60 days of maternity leave and can request an extra 30 days with permission. And women who work in the private sector are only entitled to 60 days of maternity leave. However, under the Malaysian Budget 2020, private sector maternity leave will be extended to 90 days starting 1 January 2021. However, in order to entitle to the maternity allowance, it will have several requirements to be fulfilled, which are they must be served the company with at least 90 days during her pregnancy period and must have worked at least 1 day in the last 4 months before the confinement period. For example, employee who work in the company for 88 days and giving birth on the 89 days, she will not entitled to the maternity allowance. Other than that, female employees also will not entitled to any maternity allowance according to Section 37C of Employment Act if any time of her confinement she has 5 or more surviving children. And lastly, the employee must give a prior written notice to the employer not less than 60 days from expected date of her confinement. For the payment of allowance, it will be paid either by monthly or in daily basis based on their regular payment wages. For example, if the employee is paid on monthly basis, the maternity allowance will be paid in monthly. For daily basis, the rate that has been set by the minister is RM6 per day. In addition, for the Section 39 of Employment Act, it stated that if a female employee dies from any causes during her maternity leave, she is still entitled to earn the allowance. The employer must pay the allowance to the person who represents her that has been nominated by her or her legal personal representative. The representative could be from her relative and family or someone that can act as a trustee. Furthermore, in Section 42 of Employment Act, there is a restriction on dismissal of female employee after eligible period. It stated that a female employee will not be dismissed from her occupation when she is on her maternity leave. Other than that, if a female employee is still absent after the expiration of the eligible period due to an illness approved by the registered practitioner, the employer cannot terminate the female occupation until her absence reaches 90 days. If the employer still wants to dismiss the employee despite her being in maternity period, the female employee has the right to sue and take legal action against her employer. However, there will be some situations that will allow the dismissal, such as the termination is due to the closure of employer businesses. That's all from me. Thank you.
My name is Nur Hazwa, so here I want to present the conclusions. As conclusions, the Employment Act of 1955 states as much, and it has 4 sorts of provisions which we review yearly in the study. Employers do not have the right to force their employees to undertake anything that are prohibited by the Employment Act, such as working night shifts or performing underground work. The safety of the employees is a top focus for this report and is referenced in each section of the Act. All parties involved in this problem must take it seriously and secure the safety of all employees, particularly women, because their devotion is what the firm requires throughout the work process, and the organizations must create trust with its employees. That's all from me. Thank you.